Welcome to our Constitution Day lecture. Constitution Day is actually Sunday, and I recently learned that any college that gives federal financial aid is required to have a Constitution Day where you gain some deeper insight into the Constitution. That reminded me that at my very first job when I was a graduate student at the State University of New York at Buffalo, I've had to sign a loyalty oath to uphold the Constitution of the state of New York. Of course, I wasn't from New York, so I had never read the Constitution of the state of New York. It seems to me we've come a long way if we've gotten to the point that instead of having to swear to the Constitution, we get to learn about it. We're privileged to have Judge Mishkin here with us. Recently from the Massachusetts Supreme Judicial Court, where he was arguing against the use of public funds to support a house of worship. So advocating for the separation of church and state, one of those important principles from the past. As you probably read in the promotion for this material, this meeting, he has educated people in the law about bioethics and scientists about the law. And now he's here to educate us. Thank you so much.
I want to address the following questions. What does the Constitution tell us about bioethics? What does bioethics tell us about the Constitution? And most importantly, so what? Who cares? But first, what are we doing here? In sharp, I stepped on a bit of my lines, but what is this Constitution Day? This law establishing this holiday was enacted in 2004. It does indeed require all publicly funded educational institutions to provide educational programming on the history of the American Constitution. So I am deeply honored to be used by Simon's Rock as part of your legal compliance program. It was September 17, 1987, that delegates to the Constitutional Convention signed the parchment in Philadelphia. Go to Philadelphia, stand in Independence Hall. I defy you to do it without developing a lump in your throat. How should we feel about having one more holiday to observe? I suggest that there are worse things to do with an hour of one's time than to mark this occasion. I hope at the end of our time together you won't feel otherwise. Our subject tonight is the Constitution and bioethics. Let me suggest why this subject is both interesting and important. What we call bioethics navigates the intersection of medical science and our values. This is frequently where technology takes us to places that are new to us, where technology extends the dying process, where it generates medical information previously unavailable to us, where technology facilitates reproduction to the point of forcing questions like, what is a mother? What is a father? And how many parents can one child have? Now, what can the Constitution possibly tell us about these matters when the men who wrote it didn't know what a laser is, never flew in an airplane, never rode in an automobile, never watched a television, never listened to a radio, never turned on an electric light, never made a phone call? The Constitution, with its amendments, was a political document. It set up a political system of governing. It was shaped by the politics of its time. If politics is the art of the possible, this Constitution was a measure of what was possible. Massachusetts was the 6th state to ratify the Constitution. The Massachusetts State Convention gave the new Constitution a resounding endorsement by a vote of 187 to 168. That was the vote of the delegates to the state convention. What about the popular vote in the state? Don't be silly. There was no such thing. That would have been far too democratic a process for those times. Now, there's frequently misunderstanding about what is actually in the text of the Constitution. The magnificent Jill Lepore, Harvard historian and New Yorker magazine staff writer, she has some fun with this in her entertaining and insightful essay, We the Parchment. For example, you know the preamble. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, including life, liberty, and the pursuit of happiness. Except, that's not the preamble to the Constitution. It's the second sentence to the Declaration of Independence. I can just picture Professor Lepore smiling when she noted for her readers that the person who got that wrong was a congressman who 2 years later became the then Speaker of the House of Representatives, John Boehner. So what about the Constitution's roughly 1,400 words? Here's a pop quiz. Are these words in or out of the Constitution? So for example, writ of habeas corpus, in or out of the Constitution? That's in the Constitution. Article 1, Section 9, we brought it over from English law. What about the word piracy? Yeah, piracies is in there. Article 1, Section 8. Congress has the power to define and punish piracies on the high seas. What about letters of marque and reprisal? You think it's in there, huh? How many of you have ever heard of letters of marque and reprisal? What's a letter of marque and reprisal?
It's a charter that enables pirates to sail under the flag of the nation.
Not too shabby. It's a government license authorizing a person known as a privateer to attack and capture enemy vessels and bring them before admiralty courts for condemnation and sale. And it's in the Constitution. Let's try a few more. How about God? No, it's not in there. What about separation of powers? Checks and balances? The rule of law? Privacy? Education? Healthcare? Women? None of them are in the text of the Constitution. So with that, let us, as we say, get down to cases. What does the Constitution have to say about this thing called bioethics? Or perhaps more appropriately, what have judges said it says about what we call bioethics? I'm going to discuss 3 cases with you. 2 are well known, and some of you may have heard of one or both of them. The third is not so well known, so of course, in some sense, that's the most interesting one of the 3. All 3 cases have profound implications for bioethics, but I'll give you the punchline in advance. I'm not going to try and teach you about the law. Tonight, I'm more interested in what these cases tell us about the decision makers, about the times in which they were decided, about our system of governance, and ultimately about ourselves. I'm going to apologize in advance because in discussing these cases, I'm going to quote from various opinions of different judges. And at some point, need to go on a little bit at length. If you and I ever meet in a classroom here, we would have put these texts in front of us. In fact, you would have read them carefully before coming to class. But we're going to do our best tonight with the PowerPoint and my reading to you because words are the currency of the judiciary. There's simply no way to appreciate or understand judges as they struggle with the Constitution and with each other without paying attention to their words. The first case is a case from 90 years ago, Buck versus Bell. Here are the basic facts as recited by Justice Oliver Wendell Holmes. And I'm going to quote Justice Holmes because I want you to hear from him directly. He wrote, "Carrie Buck is a feeble-minded white woman who was committed to the state colony for epileptics and feeble-minded. She's the daughter of a feeble-minded mother in the same institution and the mother of an illegitimate feeble-minded child. She was 18 years old at the time of the trial in her case." What was the trial about? A Virginia statute provided that the health of the patient and the welfare of society could be promoted in certain cases by the sterilization of mental defectives. And that statute was challenged in Carrie Buck's case. It was challenged as a violation of the 14th Amendment, that it denied Carrie Buck due process of law and equal protection of the laws. Justice Holmes continued. He said, "The Commonwealth is supporting in various institutions many defective persons who, if now discharged, would become a menace. But if incapable of procreating, if we sterilize them, they might be discharged with safety and become self-supporting with benefit to themselves and society. And that experience has shown," Justice Holmes says, "that heredity plays an important part in the transmission of insanity, imbecility, and the like." So the trial court, the first court, found that Carrie Buck is the probable potential parent of socially inadequate offspring, and that she may be sexually sterilized without detriment to her general health, and that her welfare and that of society will be promoted by her sterilization. Let me see a quick show of hands. How many of you are socially inadequate offspring? Show of hands. No. How many of you have siblings who are? How many of you are sitting next to somebody who's no, don't. Socially inadequate offspring. Justice Holmes went on. "It's better for all the world if instead of waiting to execute degenerate offspring for their crime, or to let them starve for their imbecility, it's better for all the world that society can prevent those who are manifestly unfit from continuing their kind." And he famously concluded, 3 generations of imbeciles are enough. We'll come back to Carrie Buck. Let's go from 1927 to 1990 in the case of Nancy Cruzan. On January 11, 1983, 25-year-old Nancy Cruzan lost control of her car while driving in Jasper County, Missouri. Paramedics restored her breathing and heartbeat. She lay in a coma for 3 weeks. Then it was determined she was in what is called a persistent vegetative state. Namely, there was evidence of motor reflexes, but no indications of significant cognitive function. About 8 months later, she was admitted to the Missouri Rehabilitation Center. 4 days later, her parents asked that hospital to terminate her artificial nutrition and hydration. The hospital employees said, "No, not without a court order." They go to court, and the trial court grants the parents' request. The court said that a person in Cruzan's condition had a fundamental right under the state and federal constitutions to refuse or direct the withdrawal of death-prolonging procedures. The court said Nancy Cruzan had expressed thoughts at the age of 25 in a somewhat serious conversation with a housemate friend that if she were sick or injured, she would not wish to continue her life unless she could live at least halfway normally. So the trial court gave the parents permission to do what they wanted to do for their daughter, to withdraw her artificial nutrition and hydration. End of story? Not so fast. The case went to the Missouri Supreme Court, and the Missouri Supreme Court reversed that trial court order by a vote of 5-4. The majority of the Missouri Supreme Court said that Nancy Cruzan's parents had not shown by clear and convincing evidence that she would not have wanted the artificial nutrition and hydration. Court says the parents do not have the right to make that decision absent clear and convincing evidence. Yes, there's a right to refuse treatment, but Missouri, in its laws, strongly favors the preservation of life. If you can't show it by clear and convincing evidence, you don't get to withdraw the treatment. End of story? Not so fast. What happens next? Of course, it goes to the U.S. Supreme Court. And the U.S. Supreme Court takes the case and says, we're going to consider the question of whether Cruzan had a right to require the hospital to withdraw life-sustaining treatment from her under these circumstances. The Supreme Court decided this case by a vote of 5-4. What did the court mean by under these circumstances? Chief Justice Rehnquist wrote the majority decision for the court, and he said, we assume that a competent person would have the right to refuse life-saving hydration and nutrition. What do we mean by a competent person? Somebody who has the ability to say, this is what I want, this is what I don't want, and I know what I'm talking about, okay? But of course, Nancy Cruzan was no longer competent. Persistent vegetative state, she couldn't express whatever thoughts she might have had if she had any more thoughts at that point. So somebody else is going to have to make the decision for Nancy Cruzan, and the state of Missouri says, this is Chief Justice Rehnquist repeating this, he says, if you're going to act on behalf of an incompetent person to withdraw nutrition and hydration, you have to prove by clear and convincing evidence that this patient expressed a wish to have this kind of treatment withdrawn. So the Chief Justice says the question is whether the U.S. Constitution prohibits Missouri from using that rule. Okay? Does the U.S. Constitution prohibit Missouri from saying it's got to be clear and convincing evidence? And the majority of the U.S. Supreme Court said that the U.S. Constitution does not prohibit Missouri from applying such a rule. Did the Cruzans show clear and convincing evidence? The U.S. Supreme Court says, well, the Missouri Supreme Court didn't think so, and we don't have any reason to think that they were wrong. That was the majority opinion for the court. Now it gets even more interesting. Justice O'Connor agreed with that result, but she wrote a concurring opinion. She wanted to say a little bit more than what Chief Justice Rehnquist had said. So she said, in my view, this is a very narrow decision. She says it's very narrow. It only decides about Missouri, but these issues are going to come up more frequently, and we, the U.S. Supreme Court, are going to need to be flexible when we decide these kinds of cases in the future. Okay. Justice Scalia, who also voted with the majority, writes a concurring opinion because he says, never mind Justice O'Connor saying this should be interpreted very narrowly, Justice Scalia says, this decision is broad. It should be broader. Now, whatever one may think of Justice Scalia, the justice had a way with words. Listen to what he says. He says, the federal courts have no business in this field. The point at which life becomes worthless and the point at which the means necessary to preserve it become extraordinary or inappropriate are neither set forth in the Constitution nor known to the 9 justices of this Supreme Court any better than they are known to 9 people picked at random from the Kansas City telephone directory. And hence, even when it's demonstrated by clear and convincing evidence that a patient no longer wishes certain measures to be taken to preserve his or her life, it's up to the citizens of Missouri to decide through their elected representatives, namely not judges, through their elected representatives, whether we should honor that patient's wish. He says it's quite impossible, because the Constitution says nothing about this matter. it's quite impossible that those 9 citizens will decide upon a line less lawful than the one we would choose. And it's unlikely, because those citizens know no more about life and death than, because we know no more about life and death than those citizens do, it's unlikely those citizens will decide upon a line less reasonable. 9 people picked at random from the Kansas City telephone directory. They are unlikely to decide anything less lawful than what we'll come up with, and there aren't going to be any more reasonable than us. They don't know any less than we judges know when it comes to deciding this stuff. Where are we? We have a constitutional right that's now hinging on the standard that you have to meet in court. Now, setting a standard, how hard can that be? How controversial can that be? We're trying to protect life. Who can argue with setting a high standard? Aren't we just being careful? Hold that thought. Now, don't raise your hand, but I want to ask the students here. How many of you have ever signed a document saying, here's what I want you to do or not do in case I'm ever in a persistent vegetative state? Or if I lose the capacity to make the medical decisions myself. Now, never mind if you ever signed a document. How many of you have ever sat down with your parents or your boyfriends or girlfriends or best friends or others who are close to you and given those instructions? Hold that thought. Now, let's look at the dissenting opinion in the Cruzan case by Justice William Brennan. Because Justice Brennan said, this woman, Nancy Cruzan, was entitled to die with dignity, and the Missouri Supreme Court had imposed what he called improperly biased procedural obstacles that impermissibly burdened that right. He said the state can constitutionally impose only those procedural requirements that serve to enhance the accuracy of a determination of Nancy Cruzan's wishes. Shifting the risk of error reduces the likelihood of errors in one direction at the cost of increasing the likelihood of errors in the other. Missouri came up with a clear and convincing evidence standard. That's an obstacle to exercising this fundamental right. And I love this issue because it gives me an opportunity to tell you one of my favorite stories from my own youth. My senior year of high school, a friend of mine went off to college. He invites me to join him for the weekend. I go, it's Saturday afternoon. He says, we're going to the student carnival. We get to the carnival. He says, come here, come over to this booth. I want to show you something. The booth consists of a table. On the other side of the table is a tire, like from a car, suspended in the air. The tire is right on the other side of the table. You give them a quarter, they give you a tennis ball. You're supposed to throw it through the tire. You couldn't miss, the tire was right there. I turned to my friend and I said, I don't get it. He says, what do you think the prize is for throwing the ball through the tire? I said, I don't know. And he said, a beer. And I looked at him and said, what's up with that? He said, they know. They can't sell beer, but they can give it away as a prize. Those students understand the issue on the table this moment. What's involved in setting a standard? They put that tire in a place where anyone who wanted a beer could get one. If they had moved it 100 yards away, nobody would have gotten a beer at Cornell's Carnival that afternoon. Justice Brennan was saying to the majority of the court, you've moved the tire a mile away. No one could throw a ball that far, that accurately. No 25-year-old woman would have created clear and convincing evidence of her desire not to have this kind of treatment in this extraordinary circumstance. Justice Brennan was saying, you have ensured, state of Mississippi, that many people are going to be prevented from exercising this fundamental right to withdraw this treatment. Let's review. Carrie Buck was sterilized against her wish. Nancy Cruzan was given artificial nutrition and hydration against the only available evidence of her intent and against the wishes and judgment of her parents. The explanations for these results are so different. In Cruzan, I think I observed that most people, certainly not most 25-year-olds, they don't create clear and convincing evidence of how they would want to live or not live in these situations. Well, if that's the case, then how do we explain setting a legal standard that puts this fundamental right beyond the reach of most people? I think the standard setter, I think the state of Missouri really is saying, we know there are people who are going to get unwanted medical treatment if we impose this clear and convincing standard, but that's the price of preventing mistakes, of withholding or withdrawing treatment when such a person might have wanted it to continue. This is what Justice Brennan was talking about when he referred to the risk of being wrong. Missouri says maybe Nancy Cruzan didn't want the treatment. That's a risk we're willing to take because we want to set a standard so high that we won't make the mistake the other way around of stopping treatment on people who would have wanted it. Now, every rule, every legal rule has the risk of being over-inclusive, namely requiring treatment of those who wouldn't want it, and being under-inclusive, allowing the withdrawal from somebody who wouldn't have wanted it withdrawn. Some people will respond to this by saying, maybe clear and convincing evidence isn't a high enough standard. Why not make it beyond a reasonable doubt, an even higher legal standard? And by the way, why not make it never? And others of us would say a standard that no one can meet, like the tire being a mile away, does not correspond to reality. That's Justice Brennan's point. So what about Buck versus Bell and the great Justice Oliver Wendell Holmes? Legal reasoning does not begin to explain how 8 justices could not only come to the result they came to, but to explain it the way they did. With all due respect to the other 6 justices, in some sense, it's stunning that the majority included Justices Holmes and Brandeis, both widely regarded as judicial giants. Legal reasoning doesn't really explain it. I think the explanation lies elsewhere. It lies, at least in part, in their own discomfort with somebody who is cognitively impaired. It comes from a political philosophy that Justice Holmes wrote about that justifies forsaking some people who are unable to contribute materially to society. And part of the explanation can be found in something that Justice Holmes wrote in 1881 at the age of 40, 20 years before he became a Supreme Court Justice. He, again, famously wrote, "The life of the law has not been logic, it has been experience. The substance of the law at any given time pretty nearly corresponds with what is then understood to be convenience. But its form and machinery and the degree to which it's able to work out desired results depend very much upon its past." When 8 presumably highly intelligent and educated people reach such a profoundly wrong result, defective, socially inadequate people, that's the vocabulary they use, it's hard not to conclude that those justices had a collective moral blind spot. Even more, Buck versus Bell reminds me of the single most memorable phrase I heard from any of my law school professors. If any of you are thinking about going to law school, here's a preview of coming attractions. If you're not going to law school, here's the guts of 3 years' worth of legal education. No rule of law is worth a damn outside of the facts giving rise to it. No rule of law is worth a damn outside of the facts giving rise to it. Justice Holmes came up with his ruling that Virginia could sterilize the feeble-minded based on the facts that heredity plays an important part in the transmission of insanity, imbecility, and the like. Except that we came to know that Carrie Buck, in fact, was not an imbecile in the unfortunate vocabulary of the time, or mentally defective. Law professor and historian Paul Lombardo has written a highly regarded history of the case. The title is appropriate: 3 Generations, No Imbeciles. Buck was not mentally defective. According to Professor Lombardo, the consensus is there was no reason to suspect her children would have been. There is an interesting postscript to Buck versus Bell. In late 1980, there was a class action lawsuit brought on behalf of people who were sterilized against their will in Virginia. That lawsuit revealed that from 1924 to 1979, there were 7,259 people who were sterilized involuntarily. The state compensated those it could locate, and the governor issued a formal apology. Buck versus Bell and Cruzan both include lessons about how our understanding of the facts about medical science in part shape our application of the law. So as our understanding of medical science advances, presumably so too should our sophistication in articulating the applicable legal principles. But what other kinds of advances push our understanding of constitutional principles? How about the evolution in our thinking about social relationships? To examine this question, we're going to look at the third and not so well-known case of Michael H. versus Gerald D., a case that the U.S. Supreme Court decided in 1989, and the year is important. Before I put this lecture together, I never heard of this case either. One of the justices on the Supreme Court said that the facts of this case were extraordinary. Here are the extraordinary facts. Two people got married, and then one of them had an affair. This is what happens in these cases from California, okay? The extraordinary facts. Carol and Gerald were married. Carol gave birth to Victoria, and the birth certificate showed Gerald, the husband, as being Victoria's father. This happened in 1981, before there were DNA tests. How did they determine paternity at the time? By blood tests that showed a 98% probability that Victoria's father was Michael, not Gerald. Michael being the guy with whom Carol had the affair. Michael files a lawsuit to establish paternity and the right to visitation. Victoria filed her own lawsuit saying she wanted to maintain father-daughter relationships with both Michael and Gerald. The trial court says Gerald, the husband, wins. Why? Because California has a law that says a child born to a married woman who's living with her husband, if the husband is not impotent or sterile, that child is presumed to be the child of the marriage between Carol and Gerald. Trial court says no to Victoria and no to Michael. California appellate court says, we agree. Gerald is married to Carol. He's got the sole rights as the father, despite the blood test showing the 98% probability that Michael is the biological father. Then the case goes to the U.S. Supreme Court. In the U.S. Supreme Court, we have a battle royale because Justices Scalia and Brennan go at it again. And they exchange their different views of Michael's right to assert his fatherhood of Victoria. They slugged it out over what the liberty of life, liberty, and property means in the Due Process Clause. So Justice Scalia says, hey, history and tradition are what we rely on in saying Michael doesn't have a liberty interest in his relation with Victoria, whether or not he's the biological father. It's Justice Scalia who said, the facts of this case are, we must hope, extraordinary. He says, California law, like nature itself, makes no provision for dual fatherhood. He says Michael doesn't have any constitutionally protected liberty interest in his relationship with Victoria. Listen to some of his words. He says, the Due Process Clause affords only those protections that are so rooted in the traditions and conscience of our people as to be ranked as fundamental. Our cases reflect a continual insistence upon respect for the teachings of history and solid recognition of the basic values that underlie our society. This insistence that the asserted liberty interest be rooted in history and tradition is evident in our cases. What does Justice Brennan have to say to Justice Scalia? He says the plurality, and he's talking to Justice Scalia. He says, Justice Scalia pretends that tradition places a discernible border around the Constitution. Brennan says what the deeply rooted traditions of the country are is arguable, because reasonable people can disagree about the content of particular traditions, and because they can disagree even about which traditions are relevant to the definition of liberty. So Justice Scalia has not found any kind of objective boundary. He says even if we could agree on the content and significance of particular traditions, we'd still be forced to identify the point at which a tradition becomes firm enough to be relevant to our definition of liberty, and then the moment at which it becomes too obsolete to be relevant any longer. Justice Brennan noted the connection between changing facts and changing mores. He said Justice Scalia didn't take into account the fact that the law presumed that a husband was a father of a child born to the wife before we had blood tests that could prove or disprove it. Again, Justice Brennan, he says, the atmosphere surrounding today's decision is one of make-believe. This is one Supreme Court justice talking to another. This is make-believe. He says, beginning with the suggestion that the situation confronting us here does not repeat itself every day in every corner of the country, right? And he moves on, Justice Scalia, moving on to the claim that it's tradition alone that supplies the details of the liberty that the Constitution protects. Says, when and if the court awakes to reality, it will find a world very different from the one it expects. Wow. Talk about two heavyweights going. Neither Justice Scalia nor Justice Brennan was around this year on May 17th when the New York Times ran a front-page story entitled, "Making Skin Cells into Babies, Trials in Mice Prompt What-Ifs." And that story described a process known as in vitro gametogenesis, by which two men could have a baby that's biologically related to both of them by using skin cells that could be fertilized by sperm of the other. Women with fertility problems could have eggs made from their skin cells rather than go through the lengthy and expensive process of stimulating their ovaries to retrieve their eggs. Some scientists even talk about what they call the Brad Pitt scenario, when somebody retrieves a celebrity skin cells from a hotel bed or a bathtub, or a baby might have what one law professor called multiplex parents. The professor said you could have two pairs who would each create an embryo, take an egg from one embryo, a sperm from the other, and create a baby with 4 parents. What is a parent? Is it someone who contributes genetic material? Is contributing genetic material necessary to being regarded as a parent? Is it sufficient? A world in which these questions compel our attention is a world very different from the one that Justice Scalia expected. When he died last year, commentators widely quoted Justice Scalia as saying that it riled him, it bothered him to hear people refer to the living Constitution. He reveled in calling it a dead Constitution. But many of us feel otherwise. And one reason is the explanation given by the historian Joseph Ellis in his terrific book, The Quartet. Ellis said, "The multiple ambiguities embedded in the Constitution made it an inherently living document. It was designed not to offer clear answers, but instead to provide a political arena in which arguments could continue in a deliberative fashion. The Constitution was intended less to resolve arguments than to make argument itself the solution." And then he said, talking to Justice Scalia and the like, he said, "For judicial devotees of originalism or original intent, this should be a disarming insight because it made the Constitution a foundation for an ever-shifting political dialogue that, like history itself, was an argument without end. James Madison's original intention was to make all original intentions infinitely negotiable in the future. According to Professor Ellis, there was no original intent. Justice Scalia's argument for original intention does not work historically. I submit to you there's a second reason it doesn't work. It's not how we human beings actually operate. Even were there such a thing as an original intent, there's no such thing as reading a text without interpreting it. There never has been. No two of us reads words exactly the same way. The Constitution was a text written by a committee, a political text. To explain such a text, to apply such a text, is of necessity to interpret it. Now, the boundaries and process by which we interpret are up for grabs, but let's call it what it is. We're interpreting. I and others have a third objection to the school of original intent. By what definition of democracy would a people agree to be governed by what someone or group of people thinks was intended 230 years ago by a white male aristocracy, many of whom owned slaves? Their ideas were bigger than they were, for which we can be grateful. But it's not just that they didn't know what a flashlight was. They also didn't know a society in which we insist on racial equality, gender equality, marriage equality, and the like. Now, you hear some people belittle some assertions of constitutional rights by saying, oh, the word's not even in the Constitution. Well, we established at the outset that a lot of important words are not in the Constitution, but I submit to you that every text is more than the words it expressly contains, and that this is surely the case with our Constitution. To drive my point home, I'm going to get to what I really came to talk about. In fact, what I came to sing about. Everyone here has seen, or at least knows of the movie, The Wizard of Oz. Yes? Right? The Scarecrow, Tin Man, and the Lion are looking for a brain, a heart, and courage. And by the way, if you're not familiar with The Wizard of Oz, you are not getting the full measure of a liberal arts education. If I ask you, what image comes to mind when you think of The Wizard of Oz? Most, if not all of you, eventually say, a rainbow. So how many of you know this? The book on which the movie was based, the book The Wizard of Oz by L. Frank Baum, does not contain the word rainbow. It's true. It's not in there. So how can it be that we all think of the rainbow when we think of The Wizard of Oz? It's because the man who wrote the lyrics to all of the songs in The Wizard of Oz, the great Yip Harburg, go home and Google Yip Harburg. Yip Harburg saw a rainbow in the story when he read the book. And then he wrote the song over the rainbow. Now, he didn't read the word rainbow in the book, but he saw the image. And he gave life to that image that he saw by giving that image a lyric. So now we can all see a rainbow when we think of The Wizard of Oz. Did he dishonor the story? To the contrary. I think he honored it big time by expanding upon the values that he found embedded in it. I think Yip Harburg was able to do that because he understood the moral of the stories of Buck versus Bell, of the Cruzan case, of Michael versus Gerald. He understood that intellect alone will not get the job done. That the challenge confronting each of us is to combine our intellect with our heart and our strength of character. So, although Over the Rainbow rainbow gave us the rainbow image, Yip Harburg actually explained all of this in another remarkable song from The Wizard of Oz. I could while away the hours, conferring with the flowers, consulting with the rain. And my head I'd be scratching while my thoughts were busy hatching, if I only had a brain. I'd unravel every riddle for any individual in trouble or in pain. And with the thoughts I'd be thinking I could be another Lincoln if I only had a brain. Oh, I could tell you why the ocean's near the shore. Oh, I could think of things I'd never thunk before, and then I'd sit and think some more. I would not be just a nothing, my head all full of stuffing, my heart all full of pain. And perhaps I'd deserve you and be even worthier of you if I only had a brain. When a man's an empty kettle, he should be on his mettle, and yet I'm torn apart. Just because I'm presuming that I could be kind of human if I only had a heart. I'd be tender, I'd be gentle, and awfully sentimental regarding love and art. Oh, I'd be friends with the sparrows and the guy who shoots the arrows if I only had a heart. Now picture me, a balcony above, a voice sings low. Wherefore art thou, Romeo? I hear a beat, how sweet, just to register emotion, jealousy, devotion, and really feel the part. Oh, I would stay young and chipper, and I'd lock it with a zipper if I only had a heart. Life is sad, believe me, missy, when you're born to be a sissy without the vim and verve. Ah, but I could change my habits, never more be scared of rabbits if I only had the nerve. I'm afraid there's no denying I'm just a dandelion, a fate I don't deserve. Ah, but I could show my prowess, be a lion, not a mouse, if I only had the nerve. Oh, I'd be full of pride, a king down to the core. Oh, I would roar the way I've never roared before, and then I'd ruff and roar some more. I would show the dinosaurus who's king around the forest, a king they better serve. Ah, with my regal visor I could be another Caesar if I only had the nerve. If I only had a brain. If I only had a heart. Those magnificent lyrics compel the hardest and thus the most important question we can ask ourselves on Constitution Day. It's my final pop quiz for the students, but this one's a take-home. What's in your Constitution? How will you use this year and your remaining time at Simon's Rock and beyond to combine your intellect and your compassion and your courage? What rainbow will you show us that we haven't yet seen to enrich the lives of your friends and family, your school, your community, your country, your planet? What will you contribute to the Constitution that advances our well-being? Law school has its place, but for those of you heading for other endeavors, will it be a scientific discovery that advances our empirical knowledge? Will it be a work of literature or music or art that enhances our appreciation of our freedoms of speech, religion, and assembly? Will you be a healthcare professional whose work with patients improves our understanding of how to balance respect for patient autonomy with our impulse to care for those unable to speak for themselves? Will you be a teacher, a mechanic, a counselor, a firefighter, or police officer, a small business owner, a large business owner, a government worker, a father or mother or sister or brother or child who finds new ways to spread those blessings of liberty that our Constitution was intended to secure? What are the challenges to applying the Constitution that you'll see in your lifetimes? What do we now know that time will reveal to be wrong? As we learn more about neuroscience and how the brain develops, how will that affect our application of constitutional principles to things like the sentencing of juveniles? As we learn more about genetics, what will that mean for our use of the idea of race in applying the laws against discrimination? And as technology provides us with the ability to learn more and more about ourselves and others, what will this mean for our evolving understanding of the concept of privacy? Oh, the endless possibilities for term papers. What you will do is important. Equally important is how you will do it. I gave you a sense of the fierce intellectual tug-of-war between Justices and Brennan. Remember what they said about each other's point of view. But now listen to what Justice Scalia said of his relationship with Justice Brennan. He said, "I doubt whether any two justices have dissented from one another's opinions any more regularly or any more sharply than did my former colleague, Justice William Brennan, and I. I always considered him, however, one of my best friends on the court, and I think that feeling was reciprocated." 230 years ago, 70 people were selected by the various states as delegates to the Constitutional Convention. Only 55 of them attended, and only 39 of them actually signed the document. What about us? We don't have the option of not attending or signing. We're here and we inherit what they bequeath. A bunch of white males, religiously homogenous, many of whom owned slaves, whose experience of the world was far more restricted than ours. They created this nation and this system of government that endures, warts and all these years later. We Americans are graded on a steep curve. At least once a year, it's worth remembering. Thank you, Dean Sharp. Thank you to my friend Bob Lynn somewhere else around campus, and thank you to all of you for the privilege of doing so with you tonight.
What was the final decision for the third case? What was the final decision with the paternity case?
The final decision was what the Supreme Court said, the majority said, which is it was the husband who was deemed under the law to be the father, despite the overwhelming scientific evidence that he wasn't the biological father. Now, it's an interesting case because there's a lot that goes into determining who's the father, right? And, you know, as I said, is the biological evidence determinative? Let's assume for purposes of discussion that we know that the guy she had the affair with was the biological father. We could still ask, so what? Right? How do we decide these things? Who she was living with? Who would have made a better father in the eyes of the court? There are lots of things that go into it. Questions? Comments? How the hell do you know what a letter of marque and reprisal is?
I read a lot.
You read a lot.
I do.
You gotta be careful. That can get you into trouble. I saw another hand.
What?
Yeah.
Sorry.
No, go ahead.
You go first.
No, I was just picking on it. Go ahead.
Given the conservative bent of our current Supreme Court, and that many of the decisions they're making, and you'd be more articulate than I am about which ones are in fact limiting people's rights, what do we do? What do people like you do? What can we do? I knew you were going to understand that.
Well, so the question, what you're really saying is there are at least some of us who are disturbed by what we think is the overall direction of the court. And there's diversity of opinion about that. I assume there's diversity of opinion about that sitting in the room. But, you know, for people who are concerned about that, there are a number of things that we do. One is, of course, political involvement, because as the winning side always says, when the winning side gets to select judges and the losing side doesn't like the people they pick to be judges, elections have consequences. If you want to pick the people to be on the Supreme Court, win the presidential election and control the Senate. So it's a political question. I think beyond that, this is not simple stuff, and it doesn't lend itself to black and white analysis. So for those of you who are interested in such things, reading the decisions of the Supreme Court would be interesting. By the way, now there's a podcast where you can listen to the oral arguments of cases. Listening to the oral arguments of these cases, which back in the day we didn't get to do because the Supreme Court doesn't broadcast. But to get to listen to the arguments, fascinating. And before you fall into the people on my side are smart and the other guys must be idiots, listen to the arguments. It doesn't go that way. Then there is another entire realm, which is every state has its own constitution. And those state constitutional provisions sometimes are different from the federal constitution. So Pat made a reference to a case that just by coincidence, a case that I argued last week in the Massachusetts Supreme Judicial Court, because here, ask a trial lawyer, you mentioned a trial lawyer's case, you know, I have to tell you about it. But here in Massachusetts, there's something called the Community Preservation Act. The state and localities that buy into the program give public money to people who say, we want to historically preserve this historic building. So, of course, in Massachusetts, a lot of historic buildings are inhabited by churches. And churches have gotten a lot of money under the Community Preservation Act. The problem is the state constitution says, even more strictly than the federal constitution, the state constitution says no public money can be used for the purpose of aiding a church. So Americans United for Separation of Church and State, an organization that I admire and work with, they said, let's file a lawsuit to try and stop that practice. That's what we're doing. There's an argument that we could have done it under the federal constitution, but it's much clearer under the state constitution, and people do things like that all over the country when a state constitutional provision is, for what they're trying to accomplish, more favorable than the federal constitution. So enough about my case, unless you ask me more.
So for the first case, Buck versus Bell, it took place in the eugenics era. Do you want me to repeat?
No, it took place in the eugenics era,
Yeah.
correct?
Were there any other similar cases that reached the Supreme Court, like in that time era, about eugenics, or was that the only one?
That was the major case, and then eventually Supreme Court ruled, I think it was a case in the late 1940s, where it said, okay, cut it out. That we're just not going to do that. But the fact is, the practice went on, as you heard me say, they found 7,200 people. I would presume there were more than that. Those are the people they could find. So the punchline in the end is, yes, we came to our senses, and we came to our moral sense, but it's still a stunning thing that people who are the subject of so much admiration, people like Holmes and Brandeis and the others, could reach that decision and talk about another human being in that way.
So two things, both rather brief. The first being, as far as the trial that you just recently partook in, do you feel that if the church did not continuously contain practice, if it was just a building that you were preserving for the historical implications of the church being old and they weren't holding services there, the law prohibiting public money going to religious organizations would be similarly violated?
What do you think?
That's a good question. I don't think that it would be violated.
What do you think? Let's play for a second with the students.
If the church owned it, it would still be the same.
I want to hear from the students, right? My case is about a church, an active house of worship that said to a town, give us $100,000 to do things to our building. So the question now is, what's your name?
Hayden.
Hayden, what's your last name?
Gut.
Gut. So Justice Gut asks me, right? He says, well, what if it's not an active house of worship? What if it's a building that used to be a church? We still call it a church, but they're not doing worship services in there, right? Let me give you two examples. Right here in Great Barrington, the AME Zion Church, the historic church. Until recently, it was an active house of worship. Now it's not. I believe the congregation folded and they sold the building. Now people who own it say, this is a historic church. W.E.B. Du Bois worshiped here. We want to preserve it for historic purposes. That's your question, right?
Well, who did they sell it to? I changed my original answer. If the church belongs to a religious organization, regardless of whether or not practice is going in there, I don't think money should go into. If it belongs to the state or a secular organization that's keeping it specifically for historical purposes, that's...
Then I got your vote?
Yeah.
That's okay?
Absolutely.
And that's what I think.
So even if it is not an active house of worship, it's still connected to the same name of that religion and therefore shouldn't be given state property? Like given state, funding because it is connected to that religion and serves as the same idea of promoting that religion.
All right, look, I just argued this case last week, so nothing would please me more than to keep arguing. But let me see if I can wrap it up, at least this portion of it. And by the way, in another forum, another setting, I'd be delighted to talk about the case, and to do this properly, you should hear from both sides, right? You read mine, read the others.
Have an applause and let people who have to go. And then maybe the ones who stay, you're obviously the one who stay.
So, let's let people if you want to talk, this is about the case, or you want to hear about the church case, or because if you want to do that, let me tell you just a little bit about it, and then I'm happy to take questions. And this is all a matter of public record. In the town of Acton, about 20 miles outside of Boston, a church came and said, we have financial difficulty. We need money to do things to our building, which is a historic building, so that we can use our money to do things for our members. And there were enough people willing to challenge that we were able to file a lawsuit. We wanted an injunction, a court order to stop the town from giving the money, because the town said they approved the application. So we lost in the trial court. A judge in the trial court said, the Community Preservation Act is constitutional, what's the problem? We said, well, we know the act is constitutional, but you have to apply it in a constitutional way. Surely you couldn't say we're going to give money just to the Christians and not to the other guys. You couldn't say we're going to give money just to the whites and not the blacks. I mean, there's a constitution that governs how the statutes apply. So the Supreme Judicial Court, the highest court in the state, took the case, and we just argued it last week. The town's argument is, this is about preserving old buildings. And we got a lot of old buildings in Massachusetts, and a lot of them happen to be churches. So you can't say, well, we would give the money, we would allow the money to be spent on this building, except since it's a church, we're not going to allow that, because they say that's like, that's denying people their free exercise of their religion. That's essentially the town argument. I mean, don't trust an opposing lawyer to give you the other side's argument, but that's the basics of it. And our view is, if it's an active house of worship, that's what they're doing there. They let the community come in to have meetings and all, but this is an active house of worship. In fact, in their application, they said, we need the money so we can support doing the things we do for our members. We say that has to violate the plain language of the Constitution that says no public money for the purpose of aiding or maintaining the church. I mean, that's what it says. So the questions that you started with are very much the kinds of questions that the Supreme Court was asking. And by the way, if you go to the website for the Supreme Judicial Court, they archive these arguments. So you could watch and listen to the questioning of me and the questioning of the other lawyer. So for example, we're in Massachusetts. They said, what about the Old North Church, right? Old North Church, Boston, Paul Revere. And we had talked about this in our brief. We said the Old North Church is a very good example of a distinction between this situation and them. Old North Church has about 500,000 people a year who go through it as tourists, right? It's open to the public, I don't know, 5 days a week, 7 days a week. They've got a gift shop. They sell all kinds of books, not just religious stuff. They have a separate foundation that runs the historic part of the church. And it's not church people, because there is still a congregation. Something about that? There is still a congregation that worships at the Old North Church. It's about 150 people. And what we said is, that's fine, but by any definition, the predominant use of that building is a public purpose. It's not, predominantly an active house of worship. So that's not this case.
But it hadn't been deconsecrated.
What's that?
It hadn't been removed from the function.
It's that unusual situation where it still is functioning as an active house of worship, but our view is, by no definition is that the predominant use of the building. Whereas in our case, there's no question, it's virtually the only use.
Well, not so much about the use, but you said that there's a separate foundation that maintains the historical part of the building that's open to the public.
Right. And they got the money. They got the federal money.
If they got the money, that's a secular organization, no? So if that's not a religious organization, then there's no conflict of interest between the religious...
Well, okay. So then the question is, but doesn't it still benefit the church? And the answer is, sure. Those 150 people, they are incidentally benefited by it, right? And I got the question from one of the justices. Well, so are you saying all they need to do is form a foundation? All right? And the answer was no. The point of the Old North Church having a foundation is not that the technicality of them having a foundation. It's that it represents the reality of the situation, which is 500,000 people go there every year, and they run down the building if you don't give them funds to do things. So it's not that there's a foundation, it's that there's a legitimate reason to have a foundation. That's the argument that I made, that we made. Anyway, it's a very interesting case. One of the arguments is, well, this has been going on for a long time. And my answer to that is, yes, and we had racially segregated schools for a long time until somebody said that's not constitutional. In the trial court, the judge asked me, how come nobody's tried to do anything to stop this until now? You know what the answer is? I talked to people about getting them to be plaintiffs in the lawsuit. Because in Massachusetts, if you want to challenge this, you get 10 taxpayers of the town to file a lawsuit. So we had 13 people willing to do it. But when I called people who we found one way or another in town, some people say, I agree with what you're doing, but this church is a really good church. They're a very progressive church. I said, well, now we have separation of church and state, except if it's a good church, right? That doesn't cut it. Then we had people who said, I agree with what you're doing, but my daughter is about to open a medical practice in town, and this is likely to be unpopular. And I said, you know what? Absolutely, it's going to be unpopular. You know how I know that? If it were popular, we wouldn't have to bring the lawsuit, right? And that's the whole, by the way, that's the whole point of the constitutional provision that says no money to aid a church. The history of it is we don't want these questions to be debated publicly. No citizen should have to stand up in town and say, I oppose the application of the church, right? Or how about this church gets money and this one doesn't, right? So anyway, and then there were people we talked to who said, I hate this town, they waste my money, sure, I'll join your lawsuit. So we got the Tea Party guys. And then we had people who said, I think what you're doing is right and we'll sign the lawsuit. So, anyway.
What have been some of your other favorite cases that you've argued?
Well, my own practice is, I'm an employment lawyer, and I represent employers in all kinds of disputes. Mostly it's about theft of trade secrets and breach of non-compete clauses. I also defend employers in harassment and discrimination cases. So here was a fun one. I represented a security company that was doing security work for the family of a foreign sovereign. I won't, it's a matter of public record, but a foreign sovereign that had family members that were here getting medical treatment, and they had a security detail with them. And the security detail hired my client to do security work. So a woman, security guard, employee of my client, said, I want a promotion, I want to work at the command post overnight. That was a better job in this security detail. My client said, hey, she's really good, let's put her on the command post. And they checked with the leader of the security detail of the foreign sovereign, who says, no women on the command post. Right? This was a cultural thing with them. So we said to our employee, well, we can't do it. Whereupon she sued us for gender discrimination. And I said to my associate, isn't there some kind of immunity for a sovereign, and aren't we acting on behalf of the sovereign? Go find something. 10 minutes later she came back and she said there's something called the Foreign Sovereign Immunities Act that says a foreign sovereign acting here in a sovereign capacity, not a commercial capacity. If you're acting in a sovereign capacity, you're immune from liability. So commercial things are like the government of Spain would send people here to sell Spanish wine. That's not a sovereign thing, that's a commercial thing. But here I said, who guards the king is a sovereign decision. And this is the king's family. I say it's the same thing. If the foreign sovereign would be immune, we're just the agent of the foreign sovereign. I think we get immunity. And at one point I said to the client, can I talk to Colonel Muhammad, the guy who was running security? I'd like to find out. Well, Colonel Muhammad doesn't really like to answer questions like this. And one day I was at the client's office and they said, come in. Colonel Muhammad is on the phone over here. Get on the phone. I said, Colonel Muhammad, my name is Doug Mishkin. I just want to ask you a question about that security guard. So-and-so. Click. Hangs up the phone, okay? Then, I'm in the Fourth Circuit Court of Appeals, because we won in the trial court, the other side appealed. Now, the Fourth Circuit Court of Appeals, the chief judge of the court says, Mr. Mishkin, did anybody ever try and talk to Colonel Muhammad? And I said, as an officer of the court, I will report that I tried to talk to Colonel Muhammad, and he hung up the phone on me, and that's because our State Department doesn't want foreign sovereigns to have to answer questions like this. That's why we have the statute. That's why we have immunity. So I liked that case, and I liked, I liked the back and forth.
Just a little bit. We had a situation, it was in Washington, where Turkish security guards beat the hell out of Turkish-American protesters, and now the case is going to be criminalized, and people have been identified and be arrested, but technically these were security guards who were hired by the Turkish government, and the Turkish government is claiming, I think, some version of the sovereign immunity.
Yeah, I'm not familiar with the case, but that would certainly be, that'd be the argument.
Classic, by the way. It was completely YouTubed for like 15 minutes, which almost everything is. I mean, I don't know all the facts in that case. Where in that situation where you have an act of violence, actually, I think it was in a park or something like that.
It was in a public place.
Right.
It was the the detail for the Turkish president who
Right.
had come to visit Trump.
I'm in front of
And
the
they,
White House.
and they
When there
were,
was
they
a
were
protest
very
of,
protesting
Yeah, Turkish American
his
protesters.
and they were beat up by,
Right.
they were beat up by the security guards.
I wouldn't be surprised if the immunity holds. And that sounds like a bad result, and lawyers have an expression. We say
Right.
hard cases make bad law.
There was physical assault
Yeah, there's-
on our grounds.
Before I did my case, there was one other case like it about a security company guarding, in fact, the same country's royal family. And it involved an assault. So that doesn't take it out of that realm.
It doesn't. It's terrible.
I have a question about the bioethics.
Sure.
Like, I'm studying pre-med politics, and so I've always kind of been interested in bioethics, but kind of also like skeptical, not skeptical of it, but just like not as interested because of like the whole, like just the idea of like bioethics being sort of like a field in which you're like questioning like medicine but within an ethics or something, or like you use the word like our values or like our morals, and so like, but do you see within the field of like bioethics or like bioethicists a sort of potential for like more of like a medical politics where it doesn't function within an ethics but still is able to like question medicine or something?
Well, I don't speak for all of bioethics, okay, or bioethicists, but I wouldn't articulate it as it challenging medicine. It challenges the way that we practice medicine, because, of course, medicine needs to be practiced within ethical boundaries. And our thinking about what that means has evolved dramatically over the last 100 years or so. There was a time when we did surgery on people without their consent. Then we started to call that battery, and we evolved into notions of informed consent and what that means. So I don't think it's not a challenge to the concept of practicing medicine, but very much is it's the place where the different voices get heard. The healthcare team, the caregivers, the patient, the family members, they're all a part of the decision-making process. And that's more of how I would view what bioethics is about.
Well, you were just discussing that this bioethical discussion is not an obstruction to practice, and in many cases I would disagree. I work at a hospital, and I was sitting in a case about a month and 2 weeks ago, and this case is now at 2 o'clock in the morning. It was a planned operation, and a complication arose that the patient needed a further procedure. That was not a question of consent. But for this further procedure, they could either maintain the current anesthesia or give them a more invasive anesthesia that would have had a better speed of recovery, would have been just all around better for the patient, for blood toxicity, etc. They could not give them the better anesthesia that would have been better for the longer case because the patient was unconscious and unable to give consent, and they could not locate his healthcare proxy, his wife.
Yeah, I don't give advisory opinions without a full set of facts, but that sounds unusual to me because in emergency situations, there's what's referred to as therapeutic privilege, and we just do things. We don't stand around. Whether that qualified as an emergency or really would require additional consent is not clear to me.
It's more so that they classified the different type of anesthesia as an elective instead of as necessity.
Yeah, I mean, we don't just go ahead and do surgery a second time without patient consent, whether that's from the patient himself or herself or through a surrogate decision maker. Yeah, there are issues about that come up.
So for here, the third case, the paternity one, I don't believe you mentioned the mother's stance on the case. Is that because you found that fact irrelevant or the court did?
You know, that's very interesting. I don't recall, all I know about the case is the Supreme Court decision, and I think I read some brief commentary about it, but I don't recall reading anything about the mother weighing in one way or the other. It doesn't mean she didn't, I just don't recall, I don't recall reading it. Then the question would be, would the court have cared? Right?
Do you think they would have?
What do I know?
In arguing that case, was there reference made to why the law was framed the way it was initially? In other words, the intent of the law wasn't only to privilege the father, the legal father, the legal husband, but it was also to protect children, right, from being basically repudiated. And since there wasn't scientific evidence that could establish paternity, you had to have a law that just said, look, you're the father, deal with it.
Yeah, I don't know how it was argued. All I know is what shows up in the Supreme Court's decisions, but that's what Justice Brennan is talking about. He said, you know, you're using this presumption in the statute, and that presumption was created before we knew things, never mind DNA testing that came many years later, but before we had blood tests. So, of course, you would get into, you know, a notion of, well, let's make sure the kid's protected. I mean, what other rule would you come up with if you don't have any scientific way for determining the paternity of the kid? Say, okay, you know, she's married to him, and he's not impotent, and he's not sterile, so, you know, every rule is over-inclusive and under-inclusive, and some kids, you know, under this presumption are going to be deemed to be the kid of this guy, when in fact he's not.
But it ended up protecting their interests, because if you end up being the child, let's say it's 1895 or whatever, you end up being a child of someone who's having an affair with a woman, you're socially advanced.
That's right, that's right.
So this is the only way to guarantee you have some social safety net. I also want to go back, so I like all of the ones, because we were, right? But this is not his star moment. And yet, here's the thing, is that Holmes isn't alone. Say, even Holmes and even Brandeis, and even every progressive in America in 1927 was down the line with Holmes and Brandeis. The measures that were being taken, you know, for sterilization and eugenics and generally, were not promoted by some sort of radical right-wingers. It's actually being promoted by progressives because it was a promotion of the general welfare. Right? This was a way of promoting hygiene throughout the entire country. You can go back and read Roosevelt's stuff on this earlier in the century. So my question, though, is the following: is how nimble is the law in handling when polarities reverse? What had been a progressive ideal now gets flipped around, and the progressive position has moved 180 degrees, and not all the progressives or whoever are caught up with that. How nimble should the law be in this case?
Yeah, you've asked a much bigger question than, you know, we're going to talk about at 8 o'clock tonight. It's, you know, we have the Dred Scott decision, right? And, you know, we have a Supreme Court saying, you know, black person never going to be a citizen of the country, and that needed to be undone. There are people who are waiting their turn to take that kind of shot at Roe versus Wade. So, you know, the court is an institution of law, and it's a political institution as well, and, you know, it's a you know, a complicated mix that goes into those kinds of things, because the justices, I think, you know, you would find them saying, well, it's not impossible that we're going to undo a precedent, because it happens, but they themselves struggle with how can you justify doing it, and the answer is, you know, they'll say, well, you know, we have to. Or, that was just, sometimes you just have to say that was wrong. Sometimes you just have to say that was then and this is now. Yeah. So, well, listen, this is much fun for me to get to hang around with you guys, including the over 25 crowd. And I'm just going to do a quick advertisement, which is the plan. I think I'm safe in saying this without Dean Sharp here. The plan is that I'm going to be here teaching a law and bioethics course sometime in the spring. It may be a half semester course, starting in the second half of the spring semester, but that's what I hope to do, and I think we're on board with that. So,
Did she tell you
the level, I only know one level. I'll teach you what I know, and we'll go from there. I don't know. I don't know.
Ask Dean what she thinks she's going to pitch it.
Yeah,
Determine what traffic you get.
Yeah, that I don't know.
Are you a professor here?
Yes.
Can members of the community attend classes?
You can attend my classes, but I don't get paid any more or less. So share, come and bring lunch. That's
And what
fine.
do you do?
What's that?
What do you teach?
I teach a few things, including a course on the Constitution. So that's one of my students.
I was supposed to say before my question, hi, I'm in a Constitution Amendments class, and it's taught by a really smart guy.
So I'm teaching.
Are you prepared to say that under oath? And cross-examination?
So I'm kind of thinking some of the students who've taken the course in the past would be in addition to medical-oriented students.
Sure. That'd be great.
And what's your name?
David Baum.
Palmer?
Baum, B-A-U-M.
All right.
Like L. Frank.
There you go. Thank you for coming.
Thank you.